Welcome to Raj Malhotra's IS Academy. I'm Surbhi Sirdana and this is Prelims Sprint 2022, where we will be discussing the most essential topics that you must know for cracking prelims this year. Before that, I need to inform you that all India free prelims UPSC open mock tests are being conducted by our academy. 2 of them have already been conducted on 17th April and 24th April. The next one is on 1st May 2022. These mock tests will be comprising of both GS and CSAT papers, and they will be conducted in a simulated environment, that is exactly at the time where your real when your UPSC actual exam prelims would be conducted. So register using the link given in the description below, and you can take these tests both in online mode or offline mode. You can come to our institute and sit for the test. So all the best to you. Starting with our today's discussion, the topic for today is important amendments of Indian Constitution. This is very important from examination point of view. You might be directly asked that what was the role of a particular amendment, or you might be asked question statements testing you. Examiner आपको test कर सकता है कि आप एक particular amendment के बारे में aware हैं कि नहीं है, कि what is the recent improvement that has taken place in the constitution, or a recent development that has taken place. So be aware of this. For today we will be taking 6 amendments for this lecture. We will be covering next amendments in the subsequent lectures. For today the pattern that we are following is that we are going from recent times to backwards. हम लोग इंडिपेंडेंस से अब तक की अमेंडमेंट्स नहीं कर रहे हैं, हम लोग अब से इंडिपेंडेंस की तरफ जाएंगे ताकि आपको याद रखने में आसानी हो, बिकॉज रीसेंट चीज़ जो होती है वो ज़्यादा आसानी से याद रहती है. सो वी विल गो बैक फ्रॉम 2022 to 2001 for today, and then we'll cover the previous decades in the subsequent lectures. So moving on. The first one is 102nd Amendment Act of 2018. बहुत सारी amendments आई हैं, इसके बाद भी amendments आई हैं, but they are not as important from prelims point of view, as we are taking only the important amendments here, especially from prelims point of view. So what was this 102nd Amendment of 2018? In 1993, in Indira Sahani case, Supreme Court directed the government, Supreme Court ने government को direct किया कि जो बैकवर्ड क्लासेस हैं कंट्री की, उनकी एक तो एन्यूमरेशन होनी चाहिए, प्लस देयर शुड बी अ बॉडी टू प्रोटेक्ट देयर इंटरेस्ट, बैकवर्ड क्लासेस को प्रोटेक्ट करने के लिए और उनकी डेवलपमेंट इंश्योर करने के लिए, उनका अपलिफ्टमेंट इंश्योर करने के लिए, टू इंश्योर द अपलिफ्टमेंट ऑफ बैकवर्ड क्लासेस देयर शुड बी अ बॉडी. दिस वाज द बैकग्राउंड ऑफ दिस. So in 1992, Parliament passed an act and created National Commission of Backward Classes. So till date, till 2018, this was a statutory body. National Commission of Backward Classes was a statutory body. This commission got constitutional status after this amendment, 102nd Amendment Act of 2018. जो भी आप politically regular books follow कर रहे हैं, वहाँ पर जब आप constitutional bodies के पोर्शन में जाएंगे तो नेशनल कमीशन ऑफ बैकवर्ड क्लासेस आपको दिखेगा, एंड यू हैव टू प्रिपेयर दैट इन डिटेल फॉर योर प्रीलिम्स पॉइंट ऑफ व्यू. So the 102nd Constitution Amendment Act of 2018 inserted Articles 338B, which deals with the structure, duties and powers of National Commission of Backward Classes. The structure, power of duties Article 338B में दिया, and 324A deals with the powers of the president to notify a particular caste as a socially or economically backward class. So president has that power to declare a particular caste as SCBC, and parliament has the power. Parliament के पास power है कि वो जो list है socially and economically backward classes की, उसको amend कर सके. Before this amendment, और या इस amendment से पहले, नेशनल कमीशन ऑफ शेड्यूल्ड कास्ट जो थी वो फंक्शंस परफॉर्म करती थी विद रिगार्ड टू बैकवर्ड क्लासेस. सो दिस वाज द कमीशन परफॉर्मिंग फंक्शंस. सो इसके फंक्शन से इसको रिलीव कर दिया गया. नाउ वी हैव एनसीबीसी इन प्लेस. द नेक्स्ट वन इज द 101st कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 2016. अभी हमने एक 2018 की अमेंडमेंट देखी. नाउ वी आर गोइंग बैक टू 2016. This amendment brought GST in functioning, goods and services tax into functioning. It paved the way for the introduction of the goods and services tax regime in the country. So earlier a lot of taxes were there. We have all studied about GST. amalgamate all the taxes that were creating a lot of chaos in the financial part of the country, in the financial sector of the country. To amalgamate those, this act was brought in. The special part you have to remember here is that GST Council was created under this act. So GST Council is a constitutional body, it is not a statutory body. Also, what you have to remember is the number of these constitutional amendments that we are discussing here. Previously also a question has been asked by UPSC prelims, and they do check you around the numbers. So if a match the following question comes, these amendments are more than enough. Just remember their number and their subject matter to solve such questions. The next one is 99th Amendment Act of 2014. First of all, I need to tell you, आपको ये पता होना चाहिए कि ये amendment Supreme Court ने struck down कर दी थी. This was not active. This amendment was struck down by Supreme Court as it said that this is unconstitutional. Why is it unconstitutional? Again, a question from this particular amendment has been asked directly in prelims in 2019. So read this part with very much concentration. What happened was NJAC was proposed, National Judicial Appointment Commission. The government said कि NJAC बनाते हैं, वहाँ पर बहुत सारे representatives होंगे, कुछ executive legislature से भी होंगे, काफ़ी judiciary से भी होंगे, and this commission will appoint judges to High Court and Supreme Court. As of now, how do we appoint judges? According to the 3 judges case, we appoint judges on the basis of collegium system. And what happens in collegium system? Judges are appointing next judges. So to have more uniformity, NJAC was passed. This amendment was brought in the Constitution, 99th Amendment Act, and NJAC was given a status that yes, NJAC will now be responsible for choosing the judges for High Courts and Supreme Courts and other legal officers. The Supreme Court ने कहा, Supreme Court came out with this idea of basic structure, as it was propagated in the Keshav Nanda Bharti case. Supreme Court said that separation of powers between executive, legislature and judiciary is part of basic structure of constitution, and NJAC agar aata hai, then it will violate the basic structure of constitution, because judiciary की powers को तो आप violate कर रहे हो, judiciary की powers की आप sphere में आ रहे हो. So it would violate the basic structure of constitution. So this particular amendment, this was struck down by the judiciary. Also, don't worry about reading the entire text. You can download the PDF after this lecture from the link given in the description below. Moving on. Here we have created a nice, this is a nice difference or representation between the collegium system and NJAC and what were its aims. It is not very important from examination point of view, but to take a brief overview of things that what we are talking about here, you can read about this later by downloading the PDF. Next one is the 97th Amendment Act of 2011. So it talks about cooperative societies. What is a cooperative societies? It is a jointly owned enterprise where similar minded people, they come together for their development goals, to achieve their development goals. They could be social, cultural, financial, anything. So the government decided that constitutional status should be given to cooperative societies. So it was made. So cooperative societies, right to form a cooperative society was made a part of the fundamental rights under Article 19(1) Part C. So it gave a constitutional status and protection to cooperative societies. One, in this context, it created this right, fundamental rights में cooperative societies को include किया गया, that under Article 19, it is everyone's right to form cooperative societies. DPSPs में भी change लाया गया कि that cooperative societies will be promoted, they should be promoted. It included a new directive principle of state policy on promotion of cooperative societies, Article 43B. Also, pay concentration here. Part 9B to the constitution was added, जिसमें था कि cooperative societies को constitutionalize कैसे किया जाएगा, elections कैसे होंगे, meetings कैसे होंगी. So part 9B was added to the constitution, which gave all the details relating to functioning of cooperative societies, and this part has been recently struck down by the Supreme Court. As you can see, Supreme Court in majority verdict quashes part of constitution inserted by 97th Amendment on cooperatives. So part 9B relates to the constitution and working of cooperative societies. This part has been struck down by the Supreme Court. It says that cooperative society is a state subject and states will tell, states बताएंगे कि constitution of cooperative societies और elections to cooperative societies वो कैसे होगा, ये central government नहीं बताएगी. This is not the area of central government. So part 9B has come down. Just be aware of this information. A question might be asked from this area. The next one is the 91st Constitutional Amendment Act of 2003. Now this is a very important amendment. ये तीन चीज़ें करती है. It is not just confined to one thing. It does three things. What is this? First of all, it limits the size of Council of Ministers. This is the first thing. We'll discuss about this in detail in a while. Second part is that it debars the defectors from holding public offices. And third, that it strengthens the anti-defection law which is there in place in our constitution. So moving to the first part says कि जो council of ministers होगा center पर, जिसमें prime minister भी prime minister would also be a part of that. council of ministers की जो strength है वो लोकसभा, जहाँ पर सारे legislators बैठते हैं, लोकसभा की strength से 15% से ज़्यादा नहीं होनी चाहिए. The total number of ministers including the prime minister in the central council of ministers shall not exceed 15% of the total strength of Lok Sabha. So this is the first thing that you have to keep in mind. Similar provision is there for the state governments कि जो state का जो legislative assembly है उसकी strength से 15% ज़्यादा से council of ministers of state नहीं होगा including the chief minister. So the total number of ministers including the chief minister in the council of ministers in a state shall not exceed 15% of total strength of the legislative assembly of that state. But there is a catch here कि जो strength of council of ministers of state है that cannot be less than 12 members. So this is something that you have to remember. The second part is that a member of either house of a parliament जिसको disqualify कर दिया गया है defection की वजह से, जिसने अपनी पार्टी से defect किया है and he has been disqualified from that seat, उसको हम minister नहीं बना सकते. That person cannot be appointed as a minister. Now you know that a person can become a minister and then he has to become a part of legislatures within 6 months. So that is the case. So sometimes what used to happen is कि defection हो जाती थी but उसी इंसान को जिसने defect किया है उसको किसी minister की post पर डाल देते थे. So he had 6 months to contest elections or to be a part of the legislatures again. So this provision has been added to prevent such practice for both central and state government. Let me read this out for you. A member of either house of parliament belonging to any political party who is disqualified on the grounds of defection shall also be disqualified to be appointed as a minister. Just remember that it is valid for both houses of parliament, Rajya Sabha and Lok Sabha both. So the second, similarly we have for the state that a member of either house of a state legislature, legislative council, legislative assembly, किसी भी उसका member belonging to any political party who is disqualified on the ground of defection shall also be disqualified to be appointed as a minister. And again the third and common point for both is that such people who have defected or who have been disqualified on the grounds of defection cannot hold any political post. So सिर्फ minister की ही नहीं, कोई और political post भी hold नहीं कर सकते. And the last part is, this is the fourth part here. It says कि जो आपका 10th schedule है, that is anti-defection law which is given in the constitution. उसके according पहले क्या होता था, if a party splits, if some like 1/3 people come out of a party and they form another political party, तो उसको defection नहीं मानते थे. It was not considered defection before, but now it is considered कि जो 1/3 का जो provision था on the grounds of splitting and people used to protect themselves from being disqualified on the basis of defection, that has been done away with. So the provision of the 10th schedule anti-defection law pertaining to exemption from disqualification in case of split by 1/3 members of legislative party has been deleted. It means that the defectors have no more protection on grounds of splits. Next is your 86th Amendment Act of 2002. This is very important. It gave a constitutional status to right to education. Right to education is a fundamental right. earlier what was there was DPSPs, Directive Principles of State Policy में था कि 6 to 14 years के जो बच्चे हैं, जो भी बच्चे हैं, उनको state will try to provide them with good elementary education and things like that. So now वो जो provision था that was taken out from DPSPs and it was made a part of Article 21 right to life. उसके अंदर right to education Article 21A add किया गया and it said that it is fundamental right of children who are there from 6 to 14 years of age to have this elementary education, and it made elementary education a fundamental right, added Article 21A to the Constitution, and the newly added article says that the government shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state decides. वो state decide करेगी कि हमने कैसी education provide करनी है, किस तरीके से करनी है. So but free and compulsory. So this is the provision that you have to remember. Earlier it was not there, it was part of DPSPs, then it was made a part of fundamental rights in 2002. So as I told you that it changed the subject matter of Article 45 was there in DPSPs, and what is the thing mentioned in Article 45 right now? It says कि जो 6 साल से कम के बच्चे होते हैं, children who are less than 6 years of age, the state will strive to provide them early childhood care and education. There are many schemes also that are running. DPSPs justifiable नहीं होते हैं courts में. These are like good goals that we have for our society or for our government. So this is one of those good goals that we have put in Article 45 under DPSPs. So it now reads that the state shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. Also, a new fundamental duty was added. Earlier we had just 10 fundamental duties, तो एक और duty add की गई थी इस amendment के through, 86th amendment of 2002. इसके through एक new fundamental duty was added under Article 51A, and that duty was for parents and guardians कि उनके जो भी बच्चे हैं वो उनको school भेजेंगे और उनको care provide करेंगे. So it shall be the duty of every citizen of India who is a parent or guardian to provide opportunities for education to his child or ward between the age of 6 to 14 years. आर्टिकल 21A में जो स्टेट की ड्यूटी है, जो स्टेट एक फंडामेंटल राइट प्रोवाइड कर रही है और स्टेट इंश्योर कर रही है कि हम ये चीज़ कंपल्सरी और फ्री प्रोवाइड करेंगे. इट हैज़ बीन मेड अ ड्यूटी ऑफ पेरेंट्स एंड गार्डियंस ऑल्सो दैट दे शुड ऑल्सो स्ट्राइव टू सेंड देयर चिल्ड्रन टू स्कूल और टू अरेंज एजुकेशनल अपॉर्चुनिटीज़ फॉर देयर चिल्ड्रन. So this was about today. We discussed 6 amendments. I think breaks में करेंगे तो आसानी से याद भी हो जाएगा और questions भी याद रहेंगे. We'll discuss more of them of the previous century, 20th century की जो important amendments हैं हम कल करेंगे. So see you with another discussion tomorrow. Stay tuned. If you haven't subscribed to this channel, this is the right time. All the best to you and keep working hard.